So Steve, on the count of three, I am going to start recording. So are you all ready to go?
You know, Dan, I just don't, I'm not gonna do tonight's podcast. Forget it.
Steve, wait. Steve, I set aside a lot of time here. I blocked this time out. It's my wife's birthday, and I just asked her if I could go a little bit later. And now you're telling me I didn't even have to do that. I lost a lot of points in the relationship with that request, and you're out of here. Please, I'm urging you to perform. Steve, please, will you please perform?
You know, you may just have to wait and see if I perform.
Welcome to K-Talk, Blackletter series, lesson number 11, breach versus repudiation. Steve, what has just happened here?
You know, I think there's been maybe a breach and a repudiation.
Well, let's, on this episode of K-Talk, let's figure it out. We really need theme music, don't you think?
We do. We need a band.
Yes.
We need a band that we could then
band.
Right, exactly, that we can have a little banter with.
That would be great. Okay, Steve, I think to get to that level, we're going to have to hit more than 104 views per episode. But once we hit 105 on average, I'm sure we could do that. So
and take off.
The rest is history. We can quit our day jobs. so welcome to K-Talk, lesson number 11, breach versus repudiation. We're going to talk about the difference between the two. That's what we're talking about, the difference between those two. We're not going to be talking about all the different possible issues with breach. Well, those are a lot of different issues. We're just talking about breach versus repudiation. We're leaving contract formation. We're assuming a contract has been formed. And now the question is, what kind of things can happen after contract formation? See, the sense I get with repudiation is this seems, I could be wrong, this seems to be kind of maybe a bit of a darling of bar examiner questions. It seems like often in a contracts essay, you've got one side saying, hey, I may not perform, or I'm not going to perform before the time for performance is due. Is that, am I right on that, or am I just getting that from a couple of essays that maybe I've seen?
No, you are right on that. I'm grading a midterm of my students right now where there was a repudiation, and a lot of, you know, it's sometimes it's subtle. It's hard to see sometimes, but it is very frequently tested on the Florida bar exam.
And it seems to me like this should be some easy points, because if you recognize something is a repudiation, then there's a lot of stock stuff, it seems to me, that you can then talk about that are easy points, not real complicated, and kind of move on. Is that fair?
Yeah, it's true. But I think where students mess up on the repudiation is when there's time like remaining before performance is due. And I think students miss that because they're not reading the facts close enough, because they're so nervous about the law. They're trying to see the breach, and they see that, but then they're not connecting it to the time for performance. And I think that's where they go wrong.
Perfect. Let's talk about this. Oh, by the way, I don't even know who you are. I'm Dan O'Gorman, Associate Professor at Barry University School of Law. Who are you?
You know, during the day, I'm Steve Maxwell, Director of Academic Achievement and Lecturer in Law at the University of Miami School of Law.
And after hours, you are co-host of K-Talk. Okay, that's right. So breach versus repudiation. So we, of course, know that a plaintiff, to win a claim for breach of contract, must prove that a contract was formed. Assuming the plaintiff has done that, the plaintiff then must prove that the defendant breached the contract. This word breach, though, also encompasses something called a repudiation, also known as anticipatory breach, anticipatory repudiation, just repudiation, All three of those things mean the same thing. Recognizing whether something is, what I'd say, an actual breach versus a repudiation can be important because it can bring up different issues depending upon which one it is. And just in general, it is a good idea that if you see a repudiation, to mention that it is a repudiation as opposed to a breach. So let's start with breach, the easier one. Most of this conversation is going to be about repudiation because breach is going to have its own whole host of issues. But this is really about, well, let's talk about this other kind of strange sort of relation, something related to a breach, treated as a breach, or repudiation. So a breach of contract, oh boy, see, I'm about to give you just a boring definition. You ready for this? This is boring contract structure lecture. And a breach is a failure to perform a contract duty at the time performance is due. Yawn, right?
I mean, that gets me going, but I'm
You're
weird.
excited.
Yeah.
I had you at what at time for performance is due. Whatever. So yeah, so a breach is simply, a breach is what people would think of as the classic breach, which is we enter into a contract. When you and I enter into a contract, Steve, you know what magically appears? Rights and duties. So assuming just a classic bilateral contract, you're going to have a right to my promised performance, and I will have a right to your promised performance, and I will have a duty to perform as promised, and you will have a duty to perform as promised. Rights and duties are connected. So a lot of times we think of rights and duties, the connection. I don't want to talk about torts. This is kind of like Paul's graph-ish thing. Torts has this concept too. We'll see this with third-party rights and duties. But when a contract arises, rights, bilateral rights and duties arise. And a breach of contract is when a party fails to perform one of their contract duties at the time performance is due. So in other words, see, if I promised, you promised to pay me $50 and I promised to mow your lawn in 2 weeks. When before 2 weeks passes, I cannot have breached this contract because my performance isn't due yet. I promised I would mow your lawn within 2 weeks. So if you came to me within a week, like, hey, why haven't you mowed my lawn? I'd be like, get out of here. I got 2 weeks. Leave me alone. I'm not in breach of contract yet. The time for my performance is not due. And I think everyone understands that concept. And so you can't have an actual breach of contract until that time arises. Don't come and bother me before my performance is due. Repudiation. Oh, and let me mention a couple of things about breach, even though this is really not, it's going to be maybe a little different from repudiation, but just some general concepts of breach that are important to keep in mind. In contract law, we do not care in general. I don't want to talk about defenses and excuses now. That's a later podcast. We don't care that you tried your best. Like, hey, I tried to mow your lawn, but I've never mowed a lawn before, right? So let's say you promised to mow my lawn. We'll switch it around. I tried hard, but I've never done this before. Why did I make this promise? You're falling all over yourself. I don't care. In contract law, as a general rule, contract liability is what we call strict liability, which means the measure of your duty is your promise. If you promise to mow my lawn, we're not interested in you. You've not promised to do your best. You promised to mow my lawn. And so contract liability is strict liability. It's not like, say, negligence law and torts, where the measure of your duty is to act, reasonably cautious, or as a reasonably prudent person would act. Your measure of your duty is what you promise. It's not like criminal law where some crimes will have a mens rea requirement. It doesn't matter that you didn't intend to breach. We just simply ask, did you perform as promised? If the answer to that is no, then typically, unless you got a defense or excuse, which is later, then we say that you are in breach. Repudiation. So how is repudiation different from breach? Well, so let's talk about that awkward part that I didn't realize we were recording, and our listeners got to hear a little bit of some of the tension that exists between Steve and I off camera. We're good actors, right? So we're very professional on camera. We get it together. I can act with somebody, that, maybe I got issues with, and vice versa. Steve's a professional. They saw Steve say, I'm not going to do this. So assuming Steve's contract duty was to be on the show and participate upon it actually being recorded, and assume that, that meant when I said, okay, we're going to record, not when I accidentally thought we record. Steve has announced in advance that he was not going to perform when the time for performance was due. His time to perform presumably wasn't up yet. And it's funny, it's like time to perform. It's like, makes sense, right? It's like a podcast, right? Your performance is performing. It wasn't due yet. And Steve told me in advance that he was not going to perform. We call this a repudiation. When a party, with either through a definite and unequivocal statement or a voluntary affirmative act, indicates that they are not going to perform when the time for performance becomes due, we call this a repudiation. And I'm going to pull up the actual definition because it is important. So it's either one, a party's definite and unequivocal statement that he will commit a material breach of the contract when the time for performance becomes due, or a voluntary affirmative act by the party that renders him unable or apparently unable to perform a material contract duty. And I know the restatement uses the word impossible, so it renders him unable. The restatement actually says renders it impossible or apparently impossible for him to perform a material contract duty. So tell me, how does this come up? Where on the bar exams, where, and we'll talk about the options upon repudiation, why this matters, that this is a repudiation, but just in terms of identifying a repudiation versus a breach, when would you see this come up, and what kind of guises?
In the there's been so many of them, it's hard to pick one out, but I think there was one with, it was that cakes and pies.
Oh, I love that one. Yeah, she's baking the cake, which is it's right up there. That's an interesting one, because we're not sure what the source of law is on that. Is that right? That could be, it's a hybrid contract, so it could be Article 2, it could be common law, right?
Right. And so you just had to spot, the more you spot, the better you did. And you don't have to be right. But I do think that was a UCC, because cakes and pies, were the goods. But so, yeah, that was one where it was actually, I think you had a chance to argue the demand for adequate assurance, because it was a hang up the phone and then not clarified, because the contract was formed for the cakes and the pies, and the guy bought them and the girl made them. And she called and said, hey, I wasn't expecting the raw materials to be so expensive. I need to charge you this much. And so there's a bunch of issues in there about, like, was this a attempted modification? Could this be reasonable grounds for insecurity? And I think both of those things were true. And then from a student's perspective, this is maddening, because you're like, well, wait a minute, is this a modification or is this reasonable grounds for insecurity? You don't really have to know. You just IRAC each one separately and argue both. And so that was a good example of where this played out.
That is a trick, isn't it? It's don't treat an essay necessarily the same way you treat a multiple choice question. I tell my students that if you don't know the answer to a multiple choice question, that's not good. If you don't know the answer to an essay question, that's probably good. because there is no answer. If you're confused, wait, it could be this, it could be that. That's bad on a multiple choice question, obviously. On an essay question, this might be a good sign that you're seeing, well, wait a second. Is it this? Is this attempted modification and non-repudiation? Is this a demand for adequate assurance? Has it been too long? All those questions that would be maddening on a multiple choice question because you're panicking, what is it, A, B, C, or D, are actually often good signs on an essay question. And, I can see how somebody could drive right past a repudiation because, and you bring up that bar exam one with the cakes and all that, and you see somebody say something like, look, I can't, even if they said like, I'm not going to deliver it to you. Let's say it's that stark. I promised you this and I'm not going to give it to you. I could see how your mind then, as you see the facts after that, are just jumping to those later facts. So what's the damages? Is there a defense? And you're sort of driven right by the fact that the party has announced in advance that they are not going to perform, and that is a repudiation. And you're just going into all these other issues. Maybe there's a parole evidence rule issue. There's an impracticability issue. Even, I would just think it's very easy to drive right by that. So what you are looking for, when you are taking a contracts exam or it is a contracts essay on the bar, and you see a party state in advance of the due date for performance that they are not going to perform, you definitely want to be talking about repudiation. We will talk about what flows from that, but even if nothing significant flows from that, everything else is basically the same. Let's say in that hypothetical, I'm sure you're losing points if you're not noting that was a repudiation as opposed to an actual breach.
Yes, and there was another essay where there was a dentist had hired a construction company to build him a new dental office, a new building. And the construction company laid the foundation, and there were cracks in the foundation. And the construction company was saying that, oh, those are just superficial cracks. Those are fine. That's not a problem. And the dentist hired an engineer to evaluate that foundation. And the engineer thought that was a serious problem, that you'd have to tear the whole thing down. And when the dentist told the construction company about the engineer's opinion, the construction guy says, forget it, I'm not doing this anymore. And students were so obsessed with the cracks that they didn't address the anticipatory repudiation by the construction company. So that, like, watch out what distracts you. You see something and it jumps out at you, and keep looking, because you may think that was a justified thing, that after the construction company got told, this is my engineer tells me that this is terrible, and then the refusal. And a lot of people just missed that one little thing, that he refused to continue.
Yeah, because if you think of, and what's interesting about it too is that if his due date, if he's built the whole structure, but the due date isn't there yet. So let's say he finishes a month early and it's got cracks and he refuses to finish it. One could make an argument that that's still a repudiation, even though he's done with the structure, because he's got a month to finish. And when he's saying he's refusing to fix it, what he's really saying is, I'm refusing to deliver to you a completed structure that is not problematic by the deadline. And so it's weird, right? Even some situations where it might look like it's not a repudiation could sort of be argued that it is a repudiation because the time for performance isn't due. And sometimes you can have both. Like I had in a class session recently where I was talking about repudiation, and the student asked about Alaska Packers, which we talked about in a prior podcast with the legal value, the pre-existing legal duty rule, and them sitting down and saying, we're not going to work. And, a student said, well, what is this? Would that have been a breach? Would that have been repudiation? And interestingly, I think it's actually both at once. It's kind of like what you were talking about at the outset of the show. Whereas if you're saying, I'm not going to do this and I'm walking off, if you're supposed to be doing it now, that is also a breach of the now. And it's also a repudiation of the future. So it's interesting. You can actually, in some respects, have you can have both perhaps with the same act. I'm sitting down. I'm not working. I'm supposed to be working now. That's a present breach. But I'm also telling you, as I sit down, I'm not going to get back up until you pay me more money. That is a repudiation. So let's talk about some of these things that would be construed as a definite and unequivocal statement that the party will commit a material breach, and what doesn't count as that, and being able to recognize the distinction. Because you were talking about that with the bar exam essay. Well, wait, what is this? Is it just a request for a modification, or is this repudiation? And students definitely want to keep in mind, which one is it? First thing I want to point out, though, is, Steve, there's an interesting word in that definition that I gave, which is that it has to be a definite and unequivocal statement that the person will commit a material breach, when the time for performance becomes due. Now, I'd like to back up for a second and talk about breach. Steve, when we talk about breach versus repudiation, we're talking about breach, let's say. A breach is a failure to perform a contract duty at the time performance is due, period. We don't ask whether it is a material breach, is a minor breach. It does not matter with respect to deciding if it is a breach. Even a slight deviation from that which is required under the contract is a breach. A breach is a breach is a breach. Now, students it's going to cause trouble for students down the road, because we're going to talk about a concept called the prior material breach rule. And I go, hey, wait a second, material, it's got to be material. But that's going to be about something different. We're going to talk about conditions, the law of constructive conditions. Don't worry about that now. It will matter then whether the level of breach is material or is just minor. But in just asking if something is a breach, it can be minor and it is still a breach. A party is always entitled to a remedy, even if it is just something we call nominal damages. A party is always entitled to a remedy for a breach, even if it is a minor breach. Don't ask me about Florida law. This is about general law. Florida courts have gotten a little unusual about this. We're just talking about general, what most courts are doing and what their statement says. Now, when we talk about repudiation, it has to be a statement not just that you're going to commit a breach when the time for performance becomes due, but to be a repudiation, it must be a definite and unequivocal statement that you will commit a material breach when the time for performance becomes due, that you're not going to do something important in the contract, not something minor. So that's the first thing that's a little tricky. So let's say there's some, I promise to do 20 things for you. Each one in isolation is small. And I tell you, I'm not going to do one of them in the future. That's not a repudiation if in just that is minor. And you're not going to have any, if it's not a repudiation, you're not going to have the options you would have upon a repudiation. And any sense, so I want to spend a little bit of time talking about why that is probably so, why there's this difference. Anything you want to chime in on as to why this might be different? Any guess as a student, if you put on your student hat, as to why it's maybe different? Do you care, Steve, as your student? And do you care? Does it help you to know why, or are you just like, hey, I just want to know the rule?
I do think it helps to know the why. The why gives context. It's sort of like a place to hang the information. It's the difference between a scrambled word and a word spelled correctly. It's got familiarity when we know the rationale.
I love that. Okay, so let's talk about the rationale. And to understand the rationale, you have to understand what the options are. And so I'm going to give a little bit of preview of the options, because we know one of the options is going to be that, so upon repudiation, actually, the non-repudiating parties' duties are discharged. That's what their statement tells us. They're actually automatically discharged. Not that they're in limbo, not that they're suspended. They're actually discharged. Now, we'll talk about this. We know that a repudiation can in certain situations be nullified, essentially retracted, clawed back by the repudiating parties. We know that the non-repudiating party can urge performance. So we're not necessarily going to be done for sure. But as it stands, when there's repudiation, that discharges the non-repudiating party's duties at that point. They can be resurrected, but they're currently discharged. See, that's a big deal. That, you know what that is? That's a divorce.
That's get out of jail card free.
It's a contractual divorce. We are saying you are free to go. Just like you said, you're free to go. We're calling this relationship over. And that's a big deal. That's a big deal. Because contract law generally doesn't like to do that. Contract law, much like family law, and just so you know, I don't know what I'm talking about with family law, so just don't listen to any of this. Contract law, like family law, I assume, does not want to end. They'd like to salvage relationships if they can. And the contract law is not thrilled with announcing that a contractual relationship is over. But you know, if a party says, I'm not going to perform, we really kind of have to call it over, because it wouldn't be fair to the non-repudiating party to not call it over, because the non-repudiating party typically is going to rely. When I come home and I say, I'm done, it's over, I'm out of this relationship, we believe that the non-repudiating party should be able to take that at face value. They should be able to rely upon that and move on. I'm moving on with my life. We don't want the other party to sit around. We want them to be able to move on, find another contractual partner. But so that's why discharged. It makes sense. Look, you've said it's done. I shouldn't have to talk to you about this. If you've told me it's over, I shouldn't have to talk to you about this. I should be able to go find another contractual partner.
And I want to say, what does this look like? This looks like, if there's a repudiation, 99 times out of 100, that just means the other party doesn't have to pay. So it's one of those things where it makes sense to not make them pay and then sue for breach. It just let them out of that obligation to pay. The work's not getting done. And I think when I hear it like that, it makes a lot of sense.
Just move on. There's usually not a lot to talk about. Move on. They're not going to perform. Now let's talk about a situation in which the party says, I'm not going to perform something small. We do not want divorce for this. Now, you can fill in what you think is the equivalent of a material breach warranting divorce in a true relationship versus minor. I don't want to get in trouble trying to divide that line where it is. But think about it. So I say to my wife, let's say I've told my wife, we have a deal that I'm going to take out the trash and she's going to clean the cat boxes. And I say to her, honey, just to let you know, tonight I'm not taking out the trash. The ball game is on. I don't feel like, not happening. And she's like, I want a divorce. Whoa. Let's everyone calm down, right? She's probably overreacted. And she had told me, I'm not cleaning the cat box because I don't want it tonight. And I'm like, I want a divorce. We'd probably say I've overreacted. We should not bring an end to this relationship for that. This is when I tell you, Steve, I'm not going to perform, but it's something minor. We do not want to say your duties are discharged. You're free to go find somebody else. It's like, whoa, whoa, whoa. We would think you're overreacting. So that is why, although a breach is a breach is a breach, the reason that's not that big a deal is if I have a minor breach still be a breach, is if I breach a contract with you, it's something small. I deliver the goods 2 days late. It's like no big deal. Like you don't lose a resale, anything like that, but you have a little bit of damage. It's no big deal to call that a breach because your remedy is going to be proportionate to the harm that was suffered. If it was a minor breach, your remedy will be small. It's like, I don't know, the interest on having goods delivered 2 days late. It's not going to be a lot. It's not a big deal. It's proportionate. But the consequence of an anticipatory repudiation is that your duties are discharged. You're free to go. I mean, unless we'll talk about me calling it back. But as things currently stand, you're free to go. And that's a big deal. That's a big consequence. And we don't want, it's kind of like the light switch. It's binary. It's either your duties are discharged or they're not. It's not proportional like it is with damages for a small breach. So we're going to reserve the law of repudiation for situations in which the party is saying they're not going to perform some material part of the contract. Okay, so let's talk a little bit about the difference between a statement and an act. So, and let's start with statement. So you brought up is it a modification issue? So this is a great one for professors to ask about, particularly on multiple choice, also good for essays too. So let's say, Steve, you want a contract modification and I'm the other party. Let's talk about how you could approach me to try to get a modification. So what could you do? So you're like you're unhappy. You're like the Ann Blumenthal's who we talked about in a pre-existing duty, whatever, you're the fisherman, whatever. You want a modification. How could you come to me and ask for that way? You have different options, don't you?
I do. I can come to you and say, hey, Dan, I wasn't expecting this to happen, and I could really use a change to our agreement. Or I could just kick down the door and say, no way in hell I'm holding up my end of the bargain. I got to have this.
Perfect. Exactly right. So, of course, the first one, would be a request for Steve. Very nice. I love the first Steve there. So polite. You're just asking a question. As I tell my students, I think the vast majority of the time, if you have a question mark at the end of the sentence, you're probably not going to get into much trouble, right? Now, I'm not talking about crim law, like, hey, would you like to buy some drugs? Question marks can get you in trouble in other classes. In contract law, they tend not to get you in a lot of trouble. They tend to be inquiries. You're asking for something. You're not threatening. You're not demanding. Hey, Professor Gorman, I'm in a bind. Would you be willing to pay me more money? Would you be willing to charge me less, whatever? We'd call this a request for a modification. This is not a repudiation. You've not made a definite and unequivocal statement that you're not going to perform. You've not said that. You've just told me that you're struggling. You could use some more money. It might be, I might get the sense that we might end up with you saying that, but you've not said that. So no, that is not a repudiation. So a request for modification is not a repudiation and is not going to kick in all of those ramifications of a repudiation. Now let's talk about the second Steve, a little more hot-tempered Steve. Now, what's interesting about the second Steve is the second Steve may increase the chance of extracting a modification. Right. So there may not be consideration. I don't know, but
persuasive. It's better persuasion.
You're right. It all depends, right? I mean, some people react differently to some people, but certainly the hot-tempered Steve, the busting down the door, that is going to be more effective with some people. The downside, of course, now is you have, instead of requesting a modification, well, maybe you've requested a modification, but you continued and did more. In addition to requesting modification, you also said you're not going to perform unless you get it. That is a definite and unequivocal statement that you're not going to perform when the time comes. And you say, whoa, wait a second, wait, hey, I never said that. I said I wasn't going to perform unless I got a modification. Here's the rub. A party who threatens not to perform unless they get a modification to which they are not entitled is repudiating. They are threatening not to perform when the time comes, at least under the existing contract. And so that would be repudiation. And then it would bring in all of those ramifications. So students, this is a very easy multiple choice question to draft. Number one versus number two. And students are going to have to recognize when one's repudiation and one is not a repudiation. Now, here's a restatement rule. This is an interesting one. Ready for this, Steve? I don't know how I feel about this one, but it is what the statement says. It says that if you threaten not to perform unless there's a modification, it is a repudiation, even if what you're seeking, the modification you're seeking, is something minor, because you're threatening not to perform, and that's a material breach. You're threatening not to perform at all. It doesn't matter that what you're seeking is minor. You are threatening a material breach just unless you get a minor modification.
That's why those softies in the restatement, they don't like threats. It makes them nervous. They're kind of bleeding hearts.
We can't even threaten to commit a material breach if all we're seeking is a minor modification. You're right.
Right.
What's wrong with that? So even that is considered under the statement to be a repudiation. Now, the act, a voluntary affirmative act by the party that renders him unable or apparently unable to perform material contract duty. Now, what their statement, as I said, says the voluntary affirmative act by the party that renders it performance impossible or apparently impossible. They use the word impossible, and that maybe is a better word. I got unable from a Horn book. Their statement says impossible, and probably better to stick with impossible. So let me give you an example of impossible. So impossible, I don't know if I know something that is impossible. They're almost always virtual or apparently impossible. And the question arises, what does apparently mean? I don't like that word there, Steve. I really don't. I've researched this because I had student questions about this. And I really think what their staters meant was virtually, not apparently, virtually, almost impossible. And let me explain why. Their statement gives an example of a voluntary affirmative act. So it's got to be something that you did intentionally. You chose to engage in this act. And you see this act, and this act would lead the non-repeating party to believe that based upon that act, that party is basically, it seems to me, through actions signaling, yeah, I'm not performing. It's basically almost an implied repudiation. You can think of the definite and unequivocal statement as sort of the express repudiation. Hey, I'm not going to perform when the time comes. And the act as implied that you did something and the person reasonably believes, oh yeah, he's done something that makes it now either impossible or well-nigh impossible for him to perform. He's clearly not sending me the message, he's not going to perform. And here's an example. You own a parcel of land and we have a contract where I promise to buy it, you promise to sell it. 2 weeks before the closing, you sell the parcel of land to a third party. You go to the closing, you give them the deed, they are the owner. Boy, let's face it. Do you really need to say it, Steve? Do you really need to say, I'm not coming to the closing with that deed? Your actions speak just as loud as those words. You'd have to be, just have no sense to not think that you, Steve, are not sending me the signal that you're definitely, unequivocally not going to perform when the time comes. But what's interesting about it is it's not actually impossible for you to perform.
Mhm.
You could
Yeah.
go rebuy the land. I mean, you got to convince the guy to buy it, but it could happen. Everything has a price. You can go buy the land back. And so it isn't impossible. The restatement says apparently impossible. I like the word again. I think really what they meant, because that's one of their illustrations, I think what they meant was virtually, well nigh impossible. And so that is an example of an act that would be a repudiation.
And I like to think of it as just an act inconsistent with performance. And I like that apparently thing is confusing. If I, but selling the house, that is an act inconsistent with performance. Why would you do that if you were going to perform? It doesn't make sense. So just in my mind, that's how I reconcile it or think about it.
Well, I like that. I'm actually reaching for a pen. I don't know if I have a pen, because I should scribble that in my book. I'm going to scribble that because I like that so much. An act inconsistent. I'm not taking an official position on this, just to be clear. I'm not taking.
Sure. No problem. No problem.
But I like that so much. An act inconsistent with an intention to perform. I put Steve Maxwell was here. 10, whatever it is, 1022.
Yeah.
I like that. Because what happens is where students run into trouble with this one is if somebody engages in an act, but it looks like they could do both. Steve, I don't know if you remember this case from contracts, when I taught you contracts. It was a case out of Vermont, an old case, where a quartet, a string quartet, was supposed to play another show in Vermont. And they had booked a show in another town in the afternoon, and they're supposed to get to the town where I had my opera house and play. And the problem was, it's like, wow, can you get there? Can you get to my show playing another show? Now, there were some other facts happen. There's a big snowstorm. Let's not worry about that. But the mere fact that a party has engaged in an act which might make it difficult for them to do both would typically not rise to the level of a repudiation. And I think if you remember that the act really sorts to have to send the same message that the statement would, right? The statement is not, I'm not sure I can perform. Like all these statements too, that like, hey, Steve, I'm not sure I can perform. It might be difficult. This is not a definite and unequivocal statement. You're not going to be able to perform. Expressing doubt, just like asking for modification is a repudiation. Expressing doubt about your ability to perform is not sufficiently definite and unequivocal to be a repudiation, that you're not gonna. And to me, the fact that the band has booked a show, it's going to be hard, but not impossible, not well nigh impossible, is not enough to be a repudiation. And that's where students struggle, I think, sometimes, is they see any act that might make it more difficult is not necessarily rising to the level of an act that is inconsistent with an intention to perform. It's almost you've done something where you're like basically trying to, like, really, you didn't get the message? Like when I did that, you didn't get the message that I wasn't coming? It's really going to rise to that level. And so that's the act part of it.
Yeah.
So let's now talk about probably what is the most, one of the I would say, right, recognizing that it's repudiation, big on the bar, recognizing that a request for modification is not a repudiation. And I would say maybe the next biggie, it seems to me, is, okay, what are my options? If it is a repudiation, what are my options upon repudiation?
Completely agree. And this is just a list of things that you've got to get in your head and know, because it really puts the aggrieved party in the driver's seat as to how they want to proceed. It really gives them a lot of latitude.
And you tell me if there are ones that you see that, in addition to the ones I get, because I try to narrow it down, and I've seen bar prep companies, their outlines will have sometimes a longer list than I have. I'm trying to narrow it down. And so you let me know if you think there are some that are sort of on that checklist when you're taking the bar that you should include that you don't hear. For me, the big ones when I teach my class are, number one, we know your duties are discharged, which means you, of course, can stop performing. And as a matter of fact, if you continue to perform when there's been a repudiation, you could run into some real trouble down the road when you talk about remedies, because it can be viewed as you enhancing damages. And when we get to remedies, Steve, I know you're going to want to talk about the bridge to nowhere, Luton Bridge, right? Versus
That's
Rocky.
my favorite. Yeah, that just makes me smile.
You have like 10 favorites, Steve.
I do.
That's my favorite.
It's like you're the same way. These are your babies.
Yeah, well, when we'll have to talk down the road, we talk about Luton Bridge, how you actually were one of, I think both of us were very, very close to driving to actually look for the bridge to nowhere, but then we digress, though it is my talent. We digress. But you can run into real trouble. So your duties are discharged. You're expected to stop. As a general matter, stop. You keep performing, you're in trouble, and you don't have a legal duty to continue performing if there's been a repudiation. Secondly, what you can do is you have an immediate right to sue. So this is quite important. So it seems to me that the real benefit of repudiation is that you can stop. You don't have to keep performing. It'd be ridiculous, right? I tell you, Steve, you can go ahead and build my house. I'm not paying you for it. It would be crazy that we would expect that you have a legal duty still to continue building that house. Your duties have to be discharged in any sane world. So a lot of repudiation is about this idea that you should be able to rely upon the fact that I'm not going to perform, and you shouldn't have to sit there like, a knucklehead, which I think is a legal term, a knucklehead, and continuing to build the bridge, build the house. Like, oh yeah, he said he's going to pay me, but I don't know. I think when he sees the house, he's going to do it. Or worse yet, you have to keep building that house. You're required. Your duties aren't discharged because he's not in breach yet, because he just said he wouldn't pay me, but he didn't have to pay me. The house is done, so I have no choice, and I got to build the house. This would be horrible because, of course, what we know would happen then is parties would have an incentive to build the house. And otherwise, if they're under legal duty, they got under legal duty to build a house. They're building a house for someone who doesn't want it. And this is encouraging people to engage and create products that no one wants. So that's the first thing. Your duties are discharged. You're expected, you may stop, and we expect you to stop because it makes sense. Number two, you also have an immediate right to sue. So we know that even though there hasn't been an actual breach yet, when there's repudiation, you typically, look, you can't sue before there's an actual breach. But with repudiation, we are going to speed things along. We're going to give you a ticket to allow you to go and file your lawsuit sooner than you otherwise normally could. Go right to court. And this makes sense because let's get on with our lives. Let's get this lawsuit going. Why should we have to wait till the time for performance is due when people's memories are fading? In general, other than death, sooner is better than later, right? I think in general for things. And so let's allow you to sue. So the party acquires an immediate right to sue. Now, you say, wait a second. What if I don't want a divorce? I know he repudiated, or she repudiated. I don't want him or her to go. Can I urge performance from the other side? Here's the good news. Steve, if a party wants to try to keep things together, we are fine with that. We want to allow you to urge performance. And you say, yes, but I'm nervous. If I urge performance from the other side, am I going to lose the right to sue immediately? Because I've got a right to sue. And, if I urge performance and he's not going to stay in the deal, have I been somehow prejudiced by this and lose my right to sue? And the law says, don't worry. You may urge performance, and your urging performance from the other side is not going to prejudice your ability to sue at any time between now and an actual breach, that ticket you got, hold on to your ticket that says you can sue at any time before an actual breach. Of course, you can sue when there's an actual breach, but that's the ticket is special unless you sue before. We're not going to take that ticket from you simply because you are urging performance. Does that line up with generally what you would tell students for the bar exam?
It does. It does. And the only thing that we add is can wait and see. And that makes sense. But, but really, at the end of the day, you've named the big ones that could be really issue spotted, and on the bar, which is weird. Sometimes you just list those options, but there's no facts that talk about what option was chosen. So there's not a lot to do with those. It's just something you list.
Right. That is it. Right. So on a law school exam, for many professors, that's not getting you any points. They're like, why are you telling me the option upon repudiation when none of these are in play? Whereas on the bar exam, a lot of times that will get you a little bit of credit there. That you list that. I sort of, I'm not a bar exam grader, so I'm not speaking as an expert. And just sort of my sense is that showing off works better on a bar exam essay than it does when you are writing a law school essay answer for we tend to be less impressed with showing off. And I wonder if maybe on the bar exam, it gets you a little bit further.
It does in certain areas, and this is one of them, but just listing the options and making it clear what the plaintiff could do. I think that's really, really important. And again, it's issue spotting. Like if you can see the repudiation, you're golden.
And I like that you added that you can also wait and see, because I think that is important. That the party, if they get a ticket, so there's repudiation. The first question is, do I get a repudiation ticket? And once there's repudiation, if you know it's repudiation, you get this ticket. And this ticket, of course, gives you these options. And one of the, we know right at the minute you get that ticket, your duties are discharged. But it also gives you this ticket for other options. And you can sue at any time between now and actual breach. And of course, you can always sue on actual breach. And the good news is, and on the back of it says, urging performance will in no way prejudice your right to redeem this ticket. And you can then wait. So if you you don't have to urge performance. So you can sue immediately. You can urge performance and not sue immediately. Or you can do neither of those. I cannot sue immediately, nor urge performance, and just do nothing, and that won't prejudice my right. I will go and then sue you when the breach happens. Now, I will tell you one thing that I think people generally don't talk about in contracts class, but it comes up in the real world, which is you do need to pay attention to when your jurisdiction says your cause of action accrues for purposes of statute of limitations. Many, many repudiation cases deal with the statute of limitations, because if the court says a repudiation is the equivalent of a breach and your cause of action for breach of contract, because we would call a repudiation, if you're suing when there's been a repudiation, we would still call it a claim for breach of contract. If your cause of action accrues then and you wait too long, let's say you wait 3 years to sue, but the repudiation happens, and let's say, I don't know, let's say you wait 4-ish years. If the breach happened a year after repudiation, you might be fine. But if the cause of action accrued upon the repudiation, you might be outside the statute of limitation. So one of the dangers of waiting is you gotta watch your statute of limitations. And again, this is not so much law school classes. This is or bar exam is my guess. My guess is this doesn't even get talked about in bar prep courses. This is really actually more of a real world issue. You don't want to commit malpractice. You don't want to calendar your cause of action, your statute of limitations from the actual breach if your jurisdiction is running it from a repudiation. So, I'm going to bring up a rule that no one really seems to know exactly why it exists. And my guess is you never hear about it for bar exam purposes. And if I was going to ask this on a multiple choice question, it might be like one, it's a nasty little rule. It says that, this is what their statement says. I'm going to go with what their statement says because jurisdictions are all over the place on this. Their statement says that the doctrine of repudiation does not permit a claim for damages. So the immediate, maybe specific performance, but not an immediate lawsuit for damages. So there's going to be an exception to the general rule that you can sue immediately for damages upon a repudiation. Prior to an actual breach, if the repudiating party has already received all of the non-repudiating party's performance. In such a situation, the privilege to sue for damages only arises upon an actual breach. Okay, that was a lot. So let me explain that. What that's saying is, if the non-repudiating party has already fully performed, so let's do, for example, let's do a loan contract. So if you're a bank, I'm a borrower, and you loan money to me. You have fully performed under that contract, right? Your performance is all there. Then I, the borrower, repudiate. Steve, just to let you know, I'm not paying back that loan, which I promised to pay, let's say, in installments over the next 10 years. Or even worse, it's just a single payment at the end of 10 years. And then I tell you in advance, Steve, I'm not paying. Just let you know, I'm not paying back the loan. Under their statement rule, the problem for you is that if you follow the language of that exception, you, the non-repudiating party, had already provided in full your performance to me at the time I made the repudiation, which means then, under this restatement exception, you do not have the privilege to sue me for damages until my time for performance becomes due, which means you got to sue me as each installment becomes due. Or if it was just a single kind of balloon payment at the end of 10 years, you would have to wait 10 years to sue me. What do you think of that, Steve?
That hurts. That makes me want to include something in our loan agreement to change that rule.
You are onto it. You know, that's the great thing about contracts, at least for parties who are sophisticated and know what they're doing, is once they learn a rule, they just contract around it to the extent they can. So this is a very nasty rule. A lot of jurisdictions will fiddle with this. They'll say it's limited to money, contracts for payment of money and things like that. Their statement in a comment has it just very broad like this. It's a very nasty rule. And, you know, there's disagreement as to why the rule exists. Some people say it's historical, some historical reason. One could make the argument that if you've already fully performed, you don't need the protection of the repudiation rules because you don't need to move on. There's nowhere to move on, right? You're not getting alternate performance from, you know, it's like you don't need to stop performing because you've fully performed. So we don't need to like end your performance. But it still does seems very wrong because you got to wait. And why should you have to wait? That doesn't make a lot of sense. So to get around this rule, you're absolutely right. What parties do, particularly in a situation like this with the bank, is they include a clause that is called an acceleration clause. You may have noticed these in some of the contracts you've had if you've ever borrowed money, is it says if you miss a payment, all of your payments in the future accelerate and they're all immediately due. And of course, what that does then is that then means that when I miss a payment, if all my remaining payments become due and I don't make that payment, then we now have a present breach, an actual breach, and you now don't need to worry about repudiation law to sue immediately because you can use the actual breach. And that's why a lot of times, that's why lenders will include an acceleration clause, because they are aware of some of this exception where the last thing they want to have to do is wait and sue piecemeal as every installment becomes due. All right, let's talk about, is there any risk to urging performance? So it sounded like there was no risk. I told you, Steve, that look, don't worry. You got your ticket. Urge performance from the other side, and you're not going to be prejudiced in your right to redeem that ticket. Well, sort of. There's something called a nullification of a repudiation. You can also call it a retraction. It is basically a clawing back of the repudiation. If the party who has repudiated withdraws the repudiation, indicates that they will now perform, then as long as the non-repudiating party has not detrimentally relied on it, so as your statement says, materially changed position, because that would be fair, right? When I repudiate, I'm telling you basically, look, I'm not doing it. We expect you to rely on that actually, and expect you to go out and find performance from somebody else, perform for somebody else. It would be unfair that I could come and claw back my repudiation if you had materially changed position as a result of it. So if that happens, you get your ticket. Yeah, I can't grab that ticket back from you.
And I think that makes total sense, because my duty to perform is discharged for the purpose of moving on and detrimentally relying on that repudiation.
Go sell whatever you were selling, go sell it to somebody else who wants it, right? I'm telling you, I don't want this bridge. So we are encouraging you, right? You're actually going to be in trouble if you continue building that bridge, so to speak. You continue performing. This is bad news for you. We want you to do that. So that's exactly right. So if you did exactly what we sort of are encouraging you to do, it wouldn't be fair that I could come and grab that ticket back from you. But let's say that you have not detrimentally relied. There is one other way in which I still lose the opportunity to come and take that ticket back from you. And that is if you indicate to me that you consider the repudiation to be final. Now, I don't know exactly how this has to be said. I'm sure it doesn't have to be like that. I consider this repudiation to be final. But you've got to manifest some sort of indication that we are in fact done. I mean, it's a little interesting because it is sort of final in the sense that your duties are discharged, you're free to go, but you're kind of like saying, okay, I'm serious, fine. If you're not performing, I'm out of here too. You're giving some sort of indication that you are moving on, even if you haven't actually done anything to effectuate that. You're shaking your fist and saying, yeah, fine, I'm out of here too. And I think the reason why I shouldn't be able to grab the ticket back from you at that point is people rely in subtle ways that aren't always obvious. And the material one, it might be like, you're like, look, it wasn't material, but boy, I was kind of already moving on and changing things in my head, and I did this. And it just seems like if the party announces, yeah, I'm calling your bluff, I'm out of here too, I shouldn't be able to pull that ticket back from you. And somebody in my class said, or sues. And I'm like, yeah, well, that would work too. And I think that's got to be like either material reliance or actually suing. That certainly seems to be declaring it final. It would be very strange I could pull that ticket back from you after you've actually sued. That's got to fit within one, if not both of these categories. But if neither of those have happened, no material change of position, or you haven't declared it final up until that time, either one of those events, it doesn't have to be both, either one, but before either one, I can actually come and indicate I'm going to perform, and that will have the effect of resurrecting the contract. Your duties were discharged, they were buried. And it actually is what we call a nullification. And all of the effects of repudiation are reversed. Your duties are resurrected. They breathe life back into your contract duties, and we're now back. And it's like, okay, it's like it never happened.
So I can just come back and say, I'm just kidding. I really need this job. I'm on it.
Psych,
Yeah, right.
I was joking. I'm like, Mr. Zemmer, I was joking. Seriously. Yeah, like you come back, you're like, man, yeah, I walked out of there and I'm like, I went home and like my spouse is like, are you crazy? You walk right back down there and you tell him that you're taking that back, that you are working. And if I had breached in that time period, but it was minor, I was absent for like, so I walk off, you can take this job and shove it. And I walk off and I'm off the clock for 15 minutes. I'm not working. I should be. That's a breach. There's damages for the 15 minutes. But telling you I'm quitting is indicating that I'm going to commit a material breach. I'm out of here completely. I get on my cell phone. You know what I did, honey? I just told that boss, yeah, he can take the job and shove it. You did what? You go right back there and you tell him you didn't mean it. I could actually come. And assuming it's not, I don't know, is it like a material breach to tell my boss he can take his job and shove it?
Well, not in the employment but I mean, in terms of like a contractual job, like you're working on like say it's a construction thing, not an employment that's kind of what I'm thinking.
Yeah, that's right. So I was just hired. I'm like the independent contractor, and
Right.
yeah. So that is then you have retracted, you've nullified, and you are back in business. It's like, hey, it never happened. And we like this, I think, in contract law. We like to salvage a relationship. But what's interesting? So that's the only sort of risk about urging performance. But I don't think that's much of a risk, because if you're urging performance, you must be okay with that, right?
That's what you want.
Yeah,
exactly.
Why would you urge performance? So now that is a risk of doing nothing. Like if you want to be out of there, and you just, like you said, one of the options is do nothing, right? So if you don't declare it final, and you do not, or do something to indicate you think it's final, and you haven't materialized yet, but you really would like to be out of this, then that is a risk, just sitting there and doing nothing, because then they may come back. And if they do come back and they retract, you're back in. And that does come with some risk. I kind of like all this. I mean, I can understand where students on an exam, they're like so many moving pieces, and you're under time constraints, and what's happening. Is it a repudiation? Wait, he came back and he retracted. Did he retract? Wait, was that a material change of position? He did a little bit of change of position. Was it material? And he said, okay, I guess we're done here. I guess we're done. Is that announcing it's final? It would be maddening if you're taking exam, but it's all sort of interesting in terms of a lot to unravel. So, all right.
That's a great segue to demand for adequate assurance.
Steve, I've been noticing that you've been feeling insecure recently. Is that true, Steve? Have you been feeling insecure?
Yeah, I like this. I feel like this jacket makes me look too skinny.
Well, I don't like wearing short sleeve shirts when I'm on video, because I am so skinny. So I actually like them to bulk up a little bit. I like to have a jacket. So demand for adequate assurance. So I love this rule, because why I love this rule, Steve? It makes so much sense.
It does, and it's so analogous to an insecure relationship. It's easy. It's an easy analogy here.
Didn't you write? So you took my contract theory, and I asked like I don't know, because actually I do know. You took contract theory from me, the contract theory seminar, right?
Yeah.
And you wrote your paper, I believe, on like contract law and relationships or something, didn't you?
I did. It was a little Freudian of me to do that.
Well, and I talk a lot about relationships like that in my class, and I use it as contract law. I use it as an analogy of contract law, because I think it makes it relatable. It's so boring, like repudiation, yawn, and I'm not bringing the hay or the wheat, yawn. But I think if you think of a contract as sort of a relationship between people, it helps one understand it better. And you are right. I mean, you could have, somebody might say to you that, I'm not thinking this relationship is working out. And so we have these situations where a party has not repudiated. So it hasn't risen to that high standard of a definite and unequivocal statement they're not going to perform. They just come to you and they're like, yeah, I got to let you know, I'm not sure I'm going to be able to perform. They're expressing doubt about their inability to perform. And as we talked about at the outset, that is not a repudiation. It's not strong enough. But, the poor other party is in a real quandary, because if the other party treats that, if they say, well, I'm not going to hang around. My gosh. I mean, I don't know if I'm going to get your performance. I can't continue relying on this deal. I don't want to end up performing and continuing to build this thing, and then I don't get paid. Like, I'm not so sure I'm going to pay you. What? What do I do now? The problem is the quandary that person is in is, since it's not a repudiation, then if they say, well, I'm out of here, If it turns out that the other party can prove that they would have performed, then the party who said, well, I'm out of here, is in themselves repudiating. And you're in big trouble now, right? You could get in trouble for repudiation. Whereas if they stay in it and then the other party doesn't pay, they're like, are you serious? I'm damned if I do, I'm damned if I don't. I don't know what to do. And the law recognizes this quandary for the party that is faced with what we say is like they have reasonable grounds for insecurity. It's not been a repudiation, but they have reasonable grounds to believe that the party might not perform when the time comes. And this can come either from the party making a statement that they're not sure they're going to be able to perform when the time comes. It could also arise from an act where it's not, maybe it's not a voluntary act. So remember, to be a repudiation for an act, that has to be a voluntary affirmative act. Something may have happened to that party that it wasn't a voluntary act, but now it looks like it's hard for them to perform. They may have, they may have financial troubles, that you learn that they've got a lot of creditors that are after them and you're concerned they're not going to be able to pay you when the time comes. And we call this reasonable grounds for insecurity. And the law recognizes that a party in that situation is in a quandary because it's not a repudiation, but they got to be able to do something. And the law provides this rule that allows the party to make a so-called demand for adequate assurance. It allows the party who is now insecure to ask the other party who is not yet repudiated to provide adequate assurance that they are going to perform when the time comes. It's basically like, whoa, seriously? Let's sit down. You come here and you tell me you're not sure you can perform when the time comes. I want some answers. I've got some questions. I want some answers. And I'm entitled to ask you questions to get an adequate assurance from you that you're going to be able to perform when the time comes.
And think how analogous that is to, honey, I'm going out with my guy friends for drinks tonight, and I'll be back Sunday night. Whoa.
Right.
That's not saying, hey, honey, this is over, I'm going to go and cheat on you. That's just reasonable grounds for insecurity.
Right.
And when that insecurity arises, what does your significant other want? Reasonable assurances. So unlike a relationship, the law of contracts allows this conversation to arise for clarity of the situation and what is going on.
Contract law can provide a lot of really, guidelines for managing relationships too, right? Just follow these rules, make sense. Follow these rules. I thought it was going to be worse, Steve. I thought you were going to say, the spouse says, honey, just to let you know, I'm going to a concert this weekend. It's out of town for the weekend. And I'm going with my heavy metal ex-girlfriend, just to let you know.
That's a good one too, because see, a lot of people are going to say, well, that's a repudiation. But there's too much PTSD in there, maybe. Sure. But like, be careful and evaluate the statement. Evaluate
separate rooms. Right? What's going on here? Is it like that's the only person you can find to go with you to the show? Well, I got questions. Exactly. So this is what the demand for adequate assurance is. And so if you get adequate assurance, then we're all good. We're in the contract. It doesn't rise to level. It wasn't repudiation, and it doesn't transform into repudiation. We're all good. If you do not get adequate assurance, then now in that situation under the UCC, it is treated as a repudiation. The restatement says you may treat it as a repudiation. But so it basically allows the party who doesn't get adequate assurance now to either say, they're basically saying, okay, well, this is repudiation now. It transforms it into repudiation. And so it gives this opportunity for the party who is insecure to kind of press the other party into taking one road or the other. You don't get to sit on the fence because you're basically sitting on the fence, aren't you? When you come and you say, well, I don't know if I'm going to be able to perform. I'm going to force you to go one way or the other. You're either going repudiation or you're going, yeah, I am in. But and now we got a little bit of differences between the rules. So the UCC in the rule itself in the code says that you can demand it in writing. This seems to suggest that under the UCC, it has to be in writing. Many professors probably teach that. I teach that. There are some cases out there that say, well, they don't mean it always has to be in writing, and it could be non-writing too. But at least the language of the code itself says it's got to be in writing. Under the common law restatement rule, it says it does not have to be in writing. And also under the restatement, under the UCC, a reasonable time. So you have a reasonable time to give reasonable assurance. If you do not give reasonable assurance within a reasonable time, that is when this kicks into being a repudiation of the UCC. You can treat it as a repudiation under the restatement. The amount of time, reasonable time under the UCC may not exceed 30 days. A lot of students think that means you automatically get 30 days. That's not true. It's a reasonable time not to exceed 30 days. So if the contract performance is coming in 2 weeks, 30 days is not a reasonable time. It is much shorter. Under the restatement, it is just within a reasonable time. It could exceed 30 days. That might be unusual, but tell me about the contract. Is it a really long-term contract? Is performance way down the road? Also, what's, say, reasonable assurance? Does that seem like a big adjective? Boy, adjectives are big and long. So
yeah, it's very, very muddy, but correct me if I'm wrong here, but I would think that the law would just be satisfied with clarity as to whether if these assurances push us into repudiation or performance, whatever that is.
Well, let me give you an example. Let's say, Steve, that you're contracting, you've never contracted with me before. And frankly, Steve, I'm a little shady. And so I say to you, hey, yeah, Maxwell, just to let you know, I'm not sure what accent I'm doing, frankly. Just to let you know, Maxwell, yeah, I'm not sure I'm going to be able to deliver those goods for you. I'm sorry, I just don't think I'm going to be able to deliver those goods for you. And then what do you say? So now you're feeling insecure, are you not?
Yes, I'm feeling very insecure. So I go to my email and I type an email and I ask you point blank, right? That's what I should do, right?
Sure, you should. And let's say when I told you, he says, yeah, Maxwell, boy, man, I got lots of problems. I got the, the feds are looking to shut down my business. It's all wrong. I don't know why they're doing that, but I got a lawyer. His name is Saul, and Saul is going to help me out, and I got things happening, my friend. I'm always one step ahead of those guys. They've been trying to get me for years. They haven't got me yet, but I don't know. They're looking to shut me down, not shut me down to get you that stuff. It's a bit of a mess this time. I say all that. And you're smart because you want to make sure you follow the UCC rules. Because I said good, so you're smart to type an email. You've demanded adequate assurance, and I call you up and I say, "Oh yeah, I got your email. Yeah. Okay, all right. Yeah. All right, Maxwell. I see what's going on here. Yeah. Relax. No worries. Yeah, you'll get the goods. How you feeling? Right? A little insecure?
Well, a little bit, but you did say I'll get the goods.
I did say. But remember, the rule does not require that I give you an assurance, a reasonable assurance. So you are entitled to, we don't know what that means because what is reasonable? It's circumstances matter. A party who, we know some things, a party who has a really good track record, very trustworthy, great reputation. Probably if they tell you, don't worry, you'll get it, that's a reasonable assurance. If it's somebody that is not particularly trustworthy, them just saying you'll get it is probably not a reasonable assurance. You're probably entitled to ask more questions. Wait a second, tell me about the problem with the feds. What's the status of that? What's going on? So reasonable assurance does vary. Sometimes a mere statement, I will do it, is not, that's an assurance. that doesn't necessarily mean it is a reasonable assurance. So although my guess is on most stuff on the bar exam, that's getting too far down in the weeds. My guess is on the bar exam is they're either saying, yeah, I'll do it. And you say that they've given the reasonable assurance, or they don't respond. They never respond within 30 days. It's Article 2 reasonable time. And it's probably a little bit more clearly binary as opposed to muddy in the middle and gray. Is that fair to say?
It is. In fact, the cakes and pies fact pattern where the girl who's baking the cakes and the pies calls and asks for more money, proposes that modification, actually did that in a voicemail and then left the message. And then the buyer never contacted. So there was no demand for adequate assurance. There was just silence. And the buyer ended up, covering, and that became the mess. So there was no, but you as a writer had to know that at that point, when he got that voicemail, he was entitled to ask and demand adequate assurances. But, there's nothing to apply because he didn't.
Well, and you're right. And the problem there is it sounds like, and it's been many years since I've looked at that essay, but if you only have reasonable grounds for insecurity and you don't have a repudiation, it's fine to not make a demand for adequate assurance. You're not required to. It's actually there for your benefit. But where you do run into trouble is if you treat it as a repudiation. So if you treat, this rule is designed to help you figure out whether or not it is a repudiation, it's going to be pushed into repudiation. What you don't want to do is not demand adequate, find and not demand adequate assurance and stay with the deal. What you don't want to do is not demand adequate assurance when it's not been a repudiation. There's no rule on demanding adequate assurance when there's a repudiation. Now you're urging performance. If it's a repudiation, students often do this. They see repudiation and then they think, oh, well, you should demand adequate assurance. They're thinking something different. They're thinking urging performance. If there's been a repudiation, there's no demand for adequate assurance rule in play at that point because it's repudiation. The demand for adequate assurance rule kicks in when it's not a repudiation, but there's reasonable grounds for insecurity, which involves things like you have reasonable grounds to believe they're insolvent, for example, like the UCC has a rule, and so is a statement. They're not going to be able to pay for their, and not be able to pay you when the time comes. But what's really a problem is if the party has reasonable grounds for insecurity and they pull the plug and they walk and they cover and they do something else, they could be in real trouble because they could get sued because they're really repudiating at that point in time. And that's going to be a real problem for them. So, and one other quick note, you have no right to demand adequate assurance unless you have reasonable grounds for insecurity. So if you are the type of party you're just paranoid. Hey, Steve, you're gonna perform? You're gonna perform? You're gonna perform? And you're never respond. But I never had any reasonable grounds to believe you weren't gonna perform. Nothing had happened to you that would lead me to believe you weren't going to be able to perform when the time comes. You've not said anything to lead me to believe you weren't going to perform when the time comes. I just ask you for assurance and you never respond. That does not become a repudiation. You have no legal duty to provide adequate assurance unless there was reasonable grounds for that party asking to have insecurity. Now, I wonder if you ask me, you demand adequate assurance when you have no right to. And I'm like, I'm not telling you. You have no right to ask me, so I'm not telling you. Now, I don't know if that would now create reasonable grounds for security.
Right.
I don't know. As opposed to just not responding, it's probably safer just to not respond. It's probably safer just to not mess with them and say, yes, I'm going to perform. Leave me alone. I'm going to perform.
I want to borrow that rule for a relationship. Honey, I'm going to take the trash out. Are you cheating on me?
Right.
Now,
Are you going to cheat on me? Why?
Yeah, I don't have to answer that question. I don't have to answer that.
Oh my God. That sounds like, oh my God, it'd be horrible. That sounds like reasonable grounds. I'm not telling you. You cheat on me? I'm not telling you. Oh my God.
Exactly. I think I want to borrow that rule so much.
Right. So there is, Steve, anything else, anything you think that we haven't covered, anything for the bar exam that we haven't covered? My guess is we probably covered more than the typical person would have to think about for the bar exam, but anything you can think of.
We have, but I think I want to drive that point home. The basic fundamental is this is essentially a two branch tree here, where you're looking for, is there repudiation or is there reasonable grounds for insecurity? Chances are, you may end up having to argue both, and that's a really mean professor. But if it's not a repudiation, and it's something less than an absolute unequivocal, I'm not doing this, then you've got to talk about this reasonable grounds for insecurity and go through that process. And I think a prof is much more liable to put that on your exam than a repudiation, because there's more to reasonable grounds for insecurity, in my humble opinion.
And it raises the interesting question, if a request for a modification could certainly, and I think this is sort of what you said very early on in this podcast, asking for a modification could create reasonable grounds for insecurity. I assume it all depends. It depends on what you're saying when you ask the modification. But if somebody comes to you and says, would you modify this contract and pay me more money? That's interesting. I mean, I could see a court saying that mere request for more money might be reasonable grounds to be insecure, because you're wondering, wow, do they not have the money to perform? And it might give you the right to say, wait a second, if I say no, are you going to be able to perform? And, maybe even ask for some specifics as to why were you asking for more money? Are you having money problems? So that is interesting. That makes a lot of sense to me, that really, if it's anything, if you are having an analysis in a debate on an essay, debate with yourself, whether or not something rises to the level of a repudiation, if you say yes or no, really, you should also alternatively also be discussing, well, if it doesn't rise that level, there's a very good chance, if you're just talking about repudiation, there's a very good chance that, this also then would at a minimum create reasonable grounds for insecurity. So we will leave this feeling insecure, and hope you enjoyed it. That is it for lesson number 11, breach versus repudiation. We will see you next time on K Talk.